Much obliged, Your Lordship. Your Lordship, the Council is appearing before this Honorable Supreme Court of Yavana in the matter of dignity assurance of Yavanians versus Union of Yavana, National Human Rights Commission and others versus Union of Yavana and others, Sengai Valley Dweller Society versus Union of Yavana and others on behalf of the petitioner under Article 32 and 139 capital A of the Constitution. The Council seeks permission to begin with the statement of facts, Your Lordship. Much obliged, Your Lordship. Dignity Assurance of Yavanians, an NGO, filed a bill before this Honorable Supreme Court of Yavana challenging the impunged provisions of PIMSAR Act of 2013, which was enacted to abolish the practice of manual scavenging in Yavana on the grounds that the Act is not adequate enough to curb the evil practice and the Act has provisions that may indirectly cause manual scavenging. Correspondingly, GHS, a multinational company, employed Mr. Selvendiran, Mr. Arivu, Mrs. Mangai Selvendiran to clean septic tank in their premises at Maruvai. Mr. Arivu and Mr. Selvendiran, while stepping into the septic tank, fell unconscious due to the smell. Besides, Mangai Selvendiran and Ms. Jonila, a Ethiopian research scholar, made an attempt to rescue them. Regrettably, they too fell into the tank, and consequently, all four lost their lives. In corresponding with this, NHRC on a suo motu cognizance filed a writ petition before this Honorable Supreme Court. In this, Mrs. Mersina, mother of Jonila, along with the dependents of the other three relatives, other three deceased, filed or the interveners seeking compensation for the sewer death. In the point of matter, GHS owns an incinerator plant adjacent to Sengai Valley, a gated community of 500 residents, schools, malls, temples. And apprehending the hazardous situation of the incinerator plant, the Sengai Valley Dweller Society, formed and registered by the resident, has approached GHS and then State Pollution Control Board of Poigai. Since there is no satisfactory action on both of their parts, the society has approached Supreme Court under Article 32. All the petitions were covered by this Honorable Supreme Court of Yavana. The Council seeks permission to state the issues raised, Your Lordship. Your Lordship, there are four main issues involved in this present case. That is, whether the PIMSAR Act of 2013 is constitutionally valid, whether the government has complied with its international commitments, whether the dependents of the deceased are entitled to claim compensation, whether the biomedical waste disposal regulations are fulfilling its constitutional mandates. The Council will be dealing with the first and second issue and would speak for 20 minutes, and co-counsel will be dealing with the third and fourth issue and would be speaking for 20 minutes, respectfully reserving 5 minutes for rebuttals. The Council seeks permission to move on to the arguments. Much obliged, Your Lordship. Your Lordship, the first issue is whether the PIMSAR Act of 2013 is constitutionally valid. With all due respect, on behalf of the petitioner, it is humbly submitted that the PIMSAR Act of 2013 is not constitutionally valid, which Council would establish on two grounds. Firstly, the practice of manual scavenging in Yavana is still continuing as a banned practice. And second ground, there is the inadequacy in PIMSAR Act 2013 and contradiction with the rules of 2013. It undermines and violates the fundamental rights of manual scavengers. On the first ground, the manual scavenging, this caste-based forced occupation, still exists in practice despite of the ban, and majority of the people are from the bottom of the hierarchy belonging to scheduled caste and scheduled tribe group. According to caste-related data by the Union Social Justice and Empowerment Ministry in December 2021, which is submitted as report number 1 along with the compendium for respondents, it's disclosed that 73.31% of the people who are identified as manual scavengers belong to scheduled caste. And according to a press release by the ministry on July 2022, there are 966 sewer deaths from 1993 to the date. And on the second ground, the PIMSAR Act prevails as an inadequate social legislation, Your Lordship. First, the PIMSAR Act in its section 2, subsection 1, class D, while defining hazardous cleaning, much obliged. Much obliged, Your Lordship. My ground is on the point. It's still prevailing due to the inadequacy of the law, and which undermines the fundamental right, Your Lordship. Much obliged, Your Lordship. Here, the implementation is not the issue. Here, the Act itself is inadequate to properly define what is needed for.
At all the grounds any legislation can be declared as ultra vires. Non-implementation or non-compliance of the provisions, is it a ground for challenging the constitutional validity? Is there any provisions or any citations you could substantially submit?
Much obliged, Lordship. For non-implementation cannot be a ground to decide a constitutional validity. Here, the inadequacy of the law results the failure of the implementation.
Could you cite any grounds on 75 years of constitution?
Any precedent to show that the inadequacy is a major ground to challenge to state that the law is ultra vires? Inadequacy. You are very insisting upon the inadequacy.
Much obliged, Your Lordship. Here, the inadequacy I am stating is the provisions itself is ambiguous in defining.
What particular provision is inadequate?
Much obliged, Your Lordship. The PIMSA, the 2 subsection 1 class D while defining hazardous cleaning, and section 2 subsection 1 class G while defining manual scavenging, exempt the person employed or engaged in cleaning the sewers, cleaning or handle excreta with the help of protective gears and protective devices. While prescribing 44 equipments of protective gears in rule number 4 of PIMSA rules, it failed in defining protective gears. The definition of protective gears is given in rule number 2 subsection 1 class G, which is ambiguous. It does not define the composition or number of devices one has to prescribe while employing such persons, Your Lordship.
That means what, how much he is going to clean, that much of devices has to be given. It is there. Adequate device has to be provided. That's been defined in the section like that only.
Much obliged, Your Lordship, but by definition under the section rule number 4, it can be interpreted that but just an employer giving a gloves could fulfill the criteria for protective gears, Your Lordship. Here the
law is valid, but the implementation part of the authorities, there is a lack.
Much obliged, Your Lordship. The definition itself ambiguous in defining the number of devices or composition of devices. It failed to describe it. So as a failed definition, it does not prescribe the number of devices.
Other law, this sort of laws where the number of devices or other has to be given has been stated in any other law? For safety measures take for factory as
Madam
safety
Counsel,
measures has to be given.
Number of devices depend upon, in Trichy it requires 100, whereas in Madras it requires 500. In Madurai it requires, it all depends, there are authorities, corporation authorities, local body authorities, they will decide the number of devices required.
That's what the effective role is given to the people in the process of implementation, local bodies. You want all the things should be measured by the parliament whenever they are legislating?
Much obliged, Your Lordship. Certainly not, Your Lordship. Here the number of devices is not mentioning how many devices, like how many protective gears one has to be given while entering into the tank. That is, if one has to wear a full body water suit or an oxygen mask, it doesn't define that. It does just prescribe 44 equipments, 44 protective gears, and just say whenever, like they have to provide it when they are employed.
Have you approached any local bodies for non-compliance of whatever figures you have mentioned?
No, Your Lordship.
Why? Which prevent you not to approach them? Is there any restraint in the legislation itself?
No, Your Lordship.
The exhaustive remedy is available.
Without exhaustion of any local remedy, you are directly approaching the Supreme Court as if you want a popularity, isn't it?
Much obliged, Your Lordship. But the issue here, we are raising an issue on the constitutional validity. Because
I am specifically requesting which all grounds any legislation could be declared as ultra vires. If you could list, we are happy to reserve, then we will move next issue.
yes, Your Lordship, when the Act legislation violates the fundamental rights that are guaranteed under Article.
Fundamental rights of any people are violated here?
Yes, Your Lordship.
Whose right?
Manual scavengers, those who are employed or engaged as manual scavengers.
Which article says they have a right to life or equality?
Yes, much obliged. Under 21, here this act violates Article 14 and Article 21 of the Manual Scavengers, Your Lordship.
But you only made a figure, it could be deployed only by the people who are considered as a weaker section, scheduled castes and scheduled tribes. Whether all classes of people who are born in India are engaging in the same business or same occupation, same profession?
Certainly, Your Lordship.
Equality forfeits. Then what other grounds?
Here I mentioned the percentage of scheduled tribe and scheduled caste people, because like mostly those are the people they are forced to engage in this occupation, Your Lordship. Just for the statistics, I provided the data. Here on the grounds of the fundamental rights violation.
Any section of the same act prevents or prohibits, as you use the word forcefully. Are there any penal sections are available in the same act of 2013?
Much obliged, Lordship. Yes, there are penal provisions.
Which section speaks how many then years of punishment or months of punishment?
Section 8 and 9 provides the penal provisions.
Length of punishment. First time, second time, continuous, habitual offender.
The Section 8 provides penalty for contravention of if there is a non-prohibition of insanitary latrines and employment or engagement of manual scavengers. It's with a term of imprisonment, the term which may extend up to 1 year, or fine up to 50,000 rupees, or for both. If it consequent, it may extend up to 2 years, or with fine up to.
As you have mentioned, that nobody is authorized to violate. Okay, whoever contravenes, then the penal provisions are there. Then instead of exhausting, which encourage you to directly approach the constitutional code, as if the law itself not correct in accordance with the constitutional power which is conferred to them.
Much obliged, Your Lordship. Here, once again, the council seeks to point the same point. The provision itself is ambiguous in defining what is protective gear and the composition of protective gears, Your Lordship. This lacuna itself is violating the fundamental right.
Ambiguity, is it good for the municipal authorities or local bodies to implement as and when they have a necessity? When you mention a figure, then again there is an argument. In a locality like 10,000 people, only 4 devices are.
Your Lordship, it's not about the authorities giving number of devices. It's about a person who employs or engages a person to do the work. He has to provide certain.
Under the Act to monitor all those things. Isn't it not so?
There are
complaint
authorities.
has been filed before the committee to ensure that proper devices are being used by the authorities who are utilizing these scavengers to clean the same.
No, Your Lordship, because the.
Whose approval anybody could be employed? Whether the local bodies pre-consent is a mandate or not?
Yes, Your Lordship. Under rule number 3, there is we have obtained the local authorities' permission before engaging such persons. But we can engage a person by getting a permission. We have to provide them protective gears. But the definition does not prescribe how many protective gears we have to give that person. We have to give, the same point I'm again prescribing. It says 44 protective gears or that prescribed in the rule number 4. But it does not mandate for if we are engaging a person to clean the sewer, for removing the concrete from the bottom of the tank, we have to provide them these many, these 10 devices that will protect them from dying. It does not prescribe that. So a person will provide them just the helmet or a safety goggles, so they can employ that and they can escape from that liability, Your Lordship.
Yes, Council. Could you emphasize the importance of footnote number 19?
Pardon me, Your Lordship.
Footnote number 19. Will bind the Supreme Court?
High Court of.
You read. You have footnote. That's what I'm asking. What's the relevance here? Then how do you expect the same judgment will bind the Supreme Court?
We are not expecting or mandating you to provide the same judgment. We are saying that there is a judgment based on that.
What was the judgment given?
Yes, Your Lordship.
Was there any declaration by the Odisha High Court saying any law which is made without an inclusion of social adequacy should be declared as unconstitutional?
Pardon me, Your Lordship.
No. Footnote number 19. Please read and explain.
The page number 50.
What do you have to do? That's what I'm asking.
Now, cited on authority of the High Court of Orissa versus State of Orissa.
I mentioned the arbiter dicta of Justice B.P. Rotary of Orissa High Court. in case High Court of Odisha versus State of Odisha and others, which says that it shocks the judicial conscience as it should the society's collective conscience. That the social legislation which was enacted with the special purpose of improving the socio-economic position of scheduled caste and scheduled tribe is apologize, Your Lordship. I just quoted the Orbita Dicta, which was quoted by Justice, Your Lordship. Here, this Act violates the fundamental rights on the ground under Article 14 and 21 that are guaranteed under Part 3 of the Constitution. Article 14 guarantees every people the equality before law. And in the case of State of West Bengal versus Anwar Ali Sarkar, 1952 AIR 75, the Supreme Court craved out twin test for reasonable classification. Any legislation has to fulfill the twin test or two valid essentials in order to be non-contravention with the Article 14. That is, the criteria for classification must be based on intelligible differentia and it must have a rational nexus with the object it sought to be achieved.
Any sections of the same act you have mentioned are rules in the name of TMW or sanitary rules make any distinction between X or Y, which made you to refer the Anwar Ali Sarkar case here.
Much
Any question of equality is involved.
Much obliged, Your Lordship. There is a classification between manual scavengers with protective gears and without protective gears. The Act is protecting a person engaged or employed as a manual scavenger with protective gears, but it does not protect the person without a protective gear, Your Lordship. That's the ground for the classification.
So according to river assessment, if we are not wrong, so local authorities can permit anybody, they can feel gears they can use, or if they don't want, isn't it?
The Act mandates to provide.
Act mandates, very good, because you yourself mentioned there is a section clearly mentions whoever does contravene section 7, then they could be penalized. If it is the first time, 1 year, continuous, then 2 years. Then where are the choices for you to say they can involve or engage with or without a gear?
As the point of this ground is protective gear, the definition itself is ambiguous, Your Lordship. It does not define the protective gear in a proper way. The Council seeks permission to proceed with the arguments. Much obliged, Your Lordship. In case of PEMSAR Act of 2013, the classification between manual scavengers without and with protective gears, when the definition of protective gear itself an ambiguous one, the perception behind this classification that these protective gears will protect. As due to time constraint, the Council seeks permission to sum up my arguments. Pardon me, Your Lordship. Much obliged, Your Lordship. Here, in the case of PEMSA Act, there is no intelligible differentia has been sought. Your Lordship, while the Act and there is no rational nexus, while the abstract of this Act is to abolish manual scavenging and rehabilitate manual scavengers, nonetheless, the Act exempt same by people cleaning and handling human excreta with so-called protective gears and devices. But in reality, the Act failed to implement it stronger and the equipments are either not provided at all or provided in such a pure quality. And Article 21 guarantees every person the right to life and personal liberty. And in Menaka Gandhi versus Union of India case, the Supreme Court of Yavanna gave a new dimension by saying that right to live is not merely a physical right, but it includes the right to live with human dignity. But this Act allows the people to engage or employ in manual scavenging with so-called protective gears on the basis where in a country where the social stratification is on the basis of manual work, and only a particular section of the society are engaged or forced to employ in this work, which is humiliating in nature. It violates their right to live with dignity, Your Lordship. The Council seeks permission to move on to the second issue. No, Your Lordship, it protects everyone. The Council seeks permission to move on to the second issue.
Yes.
The second issue is whether the government has completed its international commitments regarding manual scavenging and regarding the non-protection of non-citizens in Yavanna. On the first ground, as argued earlier, the manual scavenging Your Lordship, Yavanna being a party to international convention, it has obligation to abolish manual scavenging. Much obliged, Your Lordship. The Council humbly requests Your Lordships to refer page number 20 of the memorial, in which the Council quoted the Supreme Court case of Safai Karamchari Andolan versus Union of India 2014, 11 SCC 224, in which it discussed that practice of manual scavenging in Yavana violates international human rights law, including the protection found in Article 1 2 Class 1 22 of 3 of UDHR 1948, Article 2 Class 1C of International Convention on Elimination of All Forms of Racial Discrimination, and Article 5 Class A of the Convention on Elimination of All Forms of Racial Discrimination against Women. Your Lordship, according to Article 1 of Forced Labour Convention 1913, the suppression and the use of force against all forms of labour has to be eradicated. But in the case law, Prosecutor versus Krunak, Kovac and Vikovic, case number IT 9623T, it was held that if the consent of the victim is made irrelevant by use of fear or violence or psychological oppression or socio-economic condition, it is a forced labor. In Yavana, the system of social stratification, it's forcing a particular section of the society to do this. It is forcing a particular section of the society to do this menial work. It does not comply with its international commitments in this ground. And the Convention on Elimination of All Forms of Racial Discrimination against Women of 1979 casted as signatory countries with a special responsibility towards establishment of equality and protection towards rural women who are suffering from facing customs and traditional based problems, which includes manual scavenging. But according to a report by Rehabilitation Research Initiative and Social Asian Labour Network, which is provided in the memorial, page number 21, Your Lordship, from second paragraph from the last 5 lines, it was held that more than 3,189 women working as manual scavengers has reported violence, beatings and rape threats, and around 260 women stated that.
Data is applicable for this case. We are talking about the manual scavengers. Whether this data which is relevant to this case.
What is the relevance here, like, or what here?
Here, the issue is on the international commitments regarding manual scavengers, on the ground that there is a convention which implies a duty to protect women, especially the rural.
In order to satisfy the international demands, Parliament came out with a law. Okay? Is there any problem with non-compliance of the constitutional mandate or not to satisfy the different requirements whichever they are in the legislation? Where is your stand? Whether you are going to say the Parliament itself not committed, or after the commitment there is a omission by the people who are in the process of implementation.
Much obliged, Your Lordship. International commitments of a country does not stop with implementing its international domestic laws. It has to abolish what it is mandating, what the conventions are prescribing. Here, the conventions mandates to abolish practice of manual scavenging.
Whether all articles of UDHR are enforceable in India?
No, Your Lordship.
No. Why? Because you said it's a commitment. Constitutional mandate, they should translate. Then it is not a mandate, then why you are expecting whether these many figures, they are discriminating again racially? What is the link of race for the discussion which we are making? We are speaking only on Indian nationals.
Much obliged, Your Lordship. Here, the issue is whether it is fulfilling its international commitments. It's in compliance with its international commitments. Our compliance with international commitments does not stop with incorporating those things in our domestic laws. We have to implement the soul of those conventions. Here, it is to protect the rural women from the custom-based problems, which includes manual scavenging, Your Lordship. But according to the research, it is evident, even though we banned the practice, the women are suffering.
You are indirectly saying they have to leave up their occupation, whichever constitution encourages them to enjoy, isn't it?
Pardon me, Your Lordship?
Are you expecting us to say the constitutional freedom to profession and occupation should be give it up?
Certainly not, Your Lordship.
Does it confer any freedom to carry their profession, occupation and so on?
Yes, Your Lordship, under Article 19 they provide, they guaranteed that right. But I'm not stating that here, Your Lordship.
Council, for
I said that, Your Lordship. Article 122, 23 of 3, Class 3, Your Lordship. So here the Union of Yavan.
Council. So which constitutional article mandates the international commitment has to be translated in the domestic level?
Article 51, Class C, if to promote national peace and security, we have to imprint.
In a court of law?
No, Your Lordship.
Then why-
Because the Union of Yavanna have certain international commitment. It has obligation to. Your Lordship? It's fundamental. It's not. It's fundamental duties, Your Lordship.
No.
It's DPSP, Your Lordship.
Directive principles. That's.
Apologize.
Will you expect is it a hard law or soft law?
It's a soft law. The Article 6 permission to proceed with the arguments. And on the second ground, the international commitments regarding protection of non-citizens in Yavanna, and according.
How many, you said you have referred to the Sapphire and TIRUCHIRAPPALLI enrollment. Would you please, as a petitioner, can tell this court how many manual scavengers in India, in your Yavanna?
Yes, Your Lord. Much obliged, Your Lordship. We have provided the data. There are 58,198 identified manual scavengers, Your Lordship. 58,098. 58. 58098 identified manual scavengers. Due to the report, Your Lordship. The Council seeks permission to proceed with the second issue. On the second ground, the international commitments regarding the protection of non-citizens in Yavanna, and according to Article 3 of UDHR 1948, everyone has the right to life, liberty and security, which also echoes and endorsed in Article 5 of United Nations Proclaimed Declaration of Human Rights of Individuals who are not the nationals of the country in which they live in of 1958, which said that aliens must receive the same treatment as of a national of a country in regard with right to life and security of a person. And in the present case, much obliged, Your Lordship. In this present case, Mrs. Mercina, one of the petitioner who lost her daughter while during her field survey in Maruvai, when she tried to help Ms. Mangai and other two people struggling for their life, due to they are engaged in an activity that is banned by PEMSAR Act of 2013. But due to the negligence of the government, this has happened, the circumstance has happened. It violates the right to life and liberty of Ms. Janila. Here, once again, the Union of Yavanna has failed to fulfill its international commitments regarding non-citizens in Yavanna, Your Lordship. The Council humbly seeks permission to call upon my co-counsel to continue with the issue number 3 and 4. Much obliged.
Last and final clarification.
Yes, Your
According to the constitutional provisions, the duty to take care of sanitary workers, is it a state mandate or union mandate or both?
Sanitation workers comes under state list, Your Lordship.
Why you are bringing a data throughout India?
As
Sorry,
it is
throughout Yavanna?
an act is enacted by the Parliament, Your Lordship.
Okay. The second one is, you said negligence by the government. Whenever there is a negligence by the government, what all remedy constitution provides for foreigners or outside the Indians?
Under compensatory jurisprudence, we can compensate them. In Chandrima case too, we compensated the foreigner citizen. Much obliged, Your Lordship.
Okay, thank you. Yes, you can use and start. Good, thank you.
Warm greetings to the honorable bench. It's coming. Warm greetings to the honorable bench. This is co-counsel appearing on behalf of the petitioners. And co-counsel will be dealing upon issue number 3. Warm greetings to the honorable bench. This is co-counsel appearing on behalf of the petitioners, and counsel will be dealing upon issue number 3 and issue number 4 on behalf of the petitioners. Apologies, Your Lordship. Council seeks permission to proceed. Your Lordship, Council will be dealing upon issue number 3 and issue number 4 on behalf of the petitioners, Your Lordship. Council seeks permission of the Honourable Bench to state the issues dealing by the petitioners. Much obliged, Your Lordships. Issue number 3 would be whether the dependents of the deceased are entitled for compensation, and issue number 4 would be upon whether the biomedical waste regulations are fulfilling the constitutional mandates. Council seeks permission to move on to the arguments. Much obliged, Your Lordship. Your Lordship, regarding the third issue, in the present case, Your Lordship, we have 4 deceased victims. Firstly, Mr. Selvendra and Mr. Arivu entered inside the tank and fell unconscious. And besides, Mrs. Mangai and Miss Jonilia, a utopian research scholar, attempted to rescue them and regrettably lost their life and due to balance, and consequently all the 4 precious lives were lost due to suffocation, Your Lordship. In this present, due to the above incident, Your Lordship, there is a violation of fundamental rights guaranteed under Article 14 and Article 21 of the Yavana Constitution. Your Lordship, on the 4 grounds we are claiming compensation for the dependents of the deceased, Your Lordship. The first ground would be there is a vicarious liability upon the state. Secondly, there is a gross negligence by the state. And due to the above 2 grounds, there is a violation of fundamental rights guaranteed under Article 14 and Article 21. And lastly, dependents of the deceased are entitled for compensation under human rights jurisprudence in consonance with the compensatory jurisprudence, as there is a violation of Article 14 and Article 21, Your Lordship. Moving on to the main contention, Your Lordship. Firstly, under the doctrine of parens patrias, state of Yavana is within its duty to protect and control the person with disability, and hence the state cannot claim the reason of inability of a state to stop manual scavenging to escape or avoid its liability from compensating the victim's defendants, Your Lordship. And also secondly, Your Lordship, to prove the negligence in the issue, the particular circumstance constituting the event or accident in a particular case may themselves proclaim in clear and ambiguous voices of the negligence of somebody as the cause of event or accident. It has been quoted in the memorial for the petitioners under page number 26, Your Lordship. And also, Your Lordship, in the present case, we can observe 3 points to prove this offence of negligence on part of the respondents, that is the Union of Yavana. The first point would be, Your Lordship, under the Maruvai Municipal City Corporation Act 1919, which has been provided in the compendium page number 3 in the Roman number, Your Lordship, compendium of petitioners, Your Lordship. According to section 257, the commissioner is vested with the power for maintenance of system of drainage, and they fail to do the work despite the service required from the GHS at the first instance, Your Lordship. Therefore, we can see there is a breach of duty on behalf of the state. Secondly, Your Lordship, it is a duty of the sanitation response unit constructed in each district by the state to provide the safety gears before engaging them to clean.
As you have mentioned, whenever there is a breach of duty, whether the affected are entitled to claim a civil remedy or constitutional remedy.
When there is a violation of fundamental rights guaranteed by the Constitution, we are entitled for compensation, Your Lordship, for the violation of fundamental rights under the Constitution.
Is it because of tortious liability or vicarious liability?
It is a present case, there is a vicarious liability, Your Lordship, because the state has a duty to protect the citizens, Your Lordship. And also they have enacted an act called PEMSAR Act, but though it has a constitutional validity question on this present case, we are therefore going to the public law for compensation on the same basis, Your Lordship.
So does any sections of PEMSA Act encourage you to approach the constitutional court for want of a compensation?
Lordship, basically, reason why we are approaching here is, this is an unsettled position of law as there is involving of an international person for due to manual scavenging. Therefore, we are approaching the Honorable Court on basis of this, Your Lordship.
What is the nationality he belongs, the research scholar?
She belongs to Utopia, Your Lordship, utopian researcher. It is a state.
What are the essentials are requisite for status of state in international law?
Your Lordship,
Does the same state possess all 4?
Your Lordship, that is not aware by the Council, but even if it is a foreign citizen in India under Article 14, a person is also deemed to be a non-citizen, even though they are not citizens, they are guaranteed under the Article 14 and Article 21.
14 and Article 21, which is applicable foreigner also.
So you can,
Indeed.
you can move for compensation.
Apologies?
Approach this apex court.
There is a violation of fundamental right, Your Lordship, and also Council seeks to rely upon a case law, Your Lordship, which has been submitted in the memorial for petitioners also. Much obliged, Your Lordship. Indeed.
case, whether she is entitled for the compensation.
She is entitled.
Of the employees, legal and they can claim the compensation. Whether these business color can claim compensation.
Much obliged, Your Lordship. She is a
Not engaged in doing
much obliged, Your Lordship. She is a rescuer. According to the rescuer doctrine, or also if there is any volunteer. Your Lordship, it has been provided in the fact that. Yes, based on the fact, Your Lordship. Your Lordship, according to the fact, a utopian researcher, when trying to rescue, seeing them struggle due to suffocation, unfortunately she fell into the sewer. She is entitled for compensation. Your Lordship, even though if it is a vicarious liability, under the exceptions, the rescuer will be also provided compensation, Your Lordship. With the permission of the Honourable Bench, Council seeks to state a case also, Your Lordship. Yes, please. Much obliged, Your Lordship.
Number, Council?
Wow, just a moment, Your Lordship.
Yes, please. Okay, you proceed. Our co-counsel or our researcher will assist. Proceed. Next issue.
Much obliged, Your Lordship.
Yes.
Your Lordship, even though, Your Lordship, according to the facts, Your Lordship, the utopian researcher is a foreign person, Your Lordship, and as stated earlier, she is also entitled for equal protection of law guaranteed within the territory of Yavana, Your Lordship.
Yes, very good. You are correctly touching. Both Article 14 and 21 says law.
Indeed, Your
Here,
Lordship.
law. Which law allows the dependents of the deceased to initiate a proceedings in the constitutional court for want of compensation for a vicarious liability? If you say the name of the legislation, we are happy to listen from you.
Your Lordship, Council is not having the present case, Your Lordship. But Your Lordship, even in the Chandrima Das case, it was a foreign citizen, and also it was on the decided by the Honorable Supreme Court of Yavana.
Chandrima Das, the whole affected person initiated. She was not a deceased representative.
Here in your case, they are legal heirs of the person died.
For a civil proceedings, yes, you could claim, because there are different orders of CPC encourages. That's what I asked, whether you are claiming a civil remedy or constitutional remedy.
Your Lordship, Supreme Court case law is the present we are not having, but if the Honorable Bench permits, Council seeks to see a High Court judgment, Your Lordship, in regarding this, the same fact. In the case of Vimala Choritia versus State of Maharashtra 2021 case, it was regarding a manual scavenging case, Your Lordship, which was done in Maharashtra High Court, and therefore, according to that, the dependents of the deceased due to manual scavenging approached to the Honorable Court, and therefore they were provided the compensation, Your Lordship. She is a rescuer, Your Lordship. She is a rescuer.
Then how can she entitle?
manual scavenger.
Your Lordship, that is why you are claiming a compensation under the jurisprudence, Your Lordship, under the UDHR of Article 3, Your Lordship. And also in the Chandrima Das case itself, they have been guaranteed that.
Council, our bench is about to enforce the provisions under Part 3 as a fundamental right, or you want to claim the court can enforce human rights?
Your Lordship, according. Indeed.
Are they enforceable before this Ravana?
Whether all provisions of UDHR is enforceable by this bench?
Your Lordship, it is definitely not. But Council seeks to quote a judgment, Your Lordship.
Not?
Your Lordship, Your Lordship, Council seeks to quote a judgment, Your Lordship, to support the same. In case Vananda Bharati was a state of Kerala, Your Lordship, 1973, the Honorable Apex Court observed that the Universal Declaration of Human Rights may not be legally binding instrument, but it shows how Yavana understood the nature of human rights at the time Constitution was adopted. And also in Chandrima Das case, Your Lordship, it was observed by the Honorable Supreme Court of Yavana that UDHR has been recognized as a model code of conduct adopted by the United Nations General Assembly. The principle has to be read if needed in domestic jurisprudence, Your Lordship.
Model, not mandatory.
Indeed.
So we need not go by these provisions of that legal instrument you are relying upon.
But even we are providing under Article 14 as a fundamental right, Your Lordship, because our life has been lost due to rescue. and also she'll be coming under the exceptions, Your Lordship. Even there is no vicarious liability. Apologies. There is no res ispa loquitur on behalf of her even, because the rescue case will be coming under the exception of res ispa loquitur, Your Lordship.
Before approaching this court, have you ever applied to any authorities under the law? Seeking compensation or any other reliefs?
No, Your Lordship. As there is a violation of fundamental rights, we are approaching this Honorable Supreme Court under Article 32, Your Lordship. And also, Council seeks to quote a case of Romesh Thapar versus. Your Lordship, under Article 32, we can approach the Honorable Supreme Court for violation of fundamental rights. And also, Your Lordship, it has been stated in the case of Romesh Thapar was a state of Madras. We have stated in a memorial for petitioners, Your Lordship, in page number 23, from the last paragraph, it has been italic marked, Your Lordship. Accordingly, the Supreme Court observed that Article 32 provides a guaranteed remedy for the enforcement of fundamental rights. This court has thus constituted the protector and guarantor of fundamental rights, and it cannot consequently, the responsibility so laid upon, refuse to entertain a application seeking protection against the infringement of fundamental rights, Your Lordship.
Of Yavana made any law protecting human rights?
Your Lordship, the state has not made any regarding to that, but the Tamil Nadu, that is Poigai, has been implemented manual scavenging rehabilitation rules, Your Lordship, and according to that even it has been stated that the state shall be liable to compensate. Much obliged, Your Lordship.
Madam, compensation, would you please specify the quantum?
Your Lordship, according to the law, 10 lakhs shall be compensated, Your Lordship. But as we are approaching,
have you furnished any empirical data as to how you arrived at 10 lakh rupees?
it is provided in the Safai Karamchari.
What is the logical behind this arithmetic of 10 lakh?
It has been provided, it has been decided under Safai Karamchari Andolan versus Union of India. For the death of manual scavengers, 10 lakh with interest shall be provided by the state.
Irrespective of his age, irrespective of his dependents, we can come to a 10 lakhs. Can it be a straitjacket formula for everybody?
Yes, Your Lordship. That is not the reason why the judgment was given. But we are claiming that compensation for the manual scavengers, Your Lordship, the 10 lakh is provided by the held by the judgment. But for Jonila, we are asking according to the multiplier method, which has been submitted in the memorial itself, Your Lordship, according to the age, according to the profession. Dependents include. Your Lordship. Not all the dependents. Not. Yes, indeed. Not according to the definition itself. Not all the dependents will be eligible for compensation, Your Lordship. The definition has also been provided in the compendium for dependents. So, according to that, if any person comes to the Honorable Court and asks for compensation, that alone party will be provided with compensation. And also coming to the point, Your Lordship, and also the other dependents, such as if they have any other family, such as child or any other dependents, they are provided with a training facility and also alternative methods, Your Lordship, which has been provided by the state. Rehabilitation. Much obliged, Your Lordship. With the permission of the Honorable Bench, Council seeks to move on to fourth. Much obliged, Your Lordship. The fourth issue would be whether the biomedical waste regulations are fulfilling the constitutional mandate. Your Lordship, it is most humbly submitted before this Honorable Supreme Court of Yavana that the biomedical waste regulations are not fulfilling the constitutional mandates. Your Lordship, firstly, the constitutional mandates are Article 48, Article 51 AG, which has to be complied by the biomedical waste regulations and also the guidelines. Your Lordship, we are not saying that they have not implemented any rules or any guidelines, Your Lordship. They have framed biomedical rules 2016 and n number of guidelines is following the same. But under two dimensions, Your Lordship, Council seeks to explain how it is violating or not fulfilling the constitutional mandate, Your Lordship. In first dimension, Your Lordship, the impens provision under the Biomedical Rules 2016 is violating Article 21 and thus violating it is not fulfilling Article 48A of the Constitution. In the second dimension, Your Lordship, there is a lacuna in the regulation for proper implementation thus violating Article 51 AG and also Article 14 and Article 21, Your Lordship. Moving on to the main argument, Your Lordship. Firstly, in the Biomedical Waste Regulation Rules 2016, according to, it has been provided in the Compendium 368, Your Lordship, Biomedical Rules. In the compendium there, Your Lordship. Yes, much obliged, Your Lordship. According to the rule 3E, 4B, 71, 72, 75, 76 and 82, Your Lordship, and according to Schedule 1, the main concept of impunged provision, Schedule 1 of Biomedical Rule 2016, Part 1 states that yellow category waste shall be incinerated directly without any post-treatment or segregation, Your Lordship. That is the reason why we are approaching this Honorable Supreme Court, as it violates the incinerator plant due to its dioxins and fumes which has been generated to the incinerator are violating the right to life which is being guaranteed under the Constitution of Yavana. And also, Your Lordship, Council seeks to provide that according to scientific proven research which is published in National Library of Medicine and National Center Biotechnology Information, Your Lordship, the research paper has been submitted in the Compendium 492, Your Lordship. It is a proven research paper with the statistics and also the formula, Your Lordship, how they derived to the same. Before coming to that,
So we can insert it in the law. With that, should it be declared as ultra vires?
apologies, Your
Whatever
Lordship.
suggestion the researcher made can be implemented. Can be incorporated as through an amendment, and when we can make the law more effective.
That is not the point we are coming to say, Your Lordship. When comparing to the other countries such as Denmark and Philippines, they have completely banned the incinerators. And also China has come to an alternative form of providing of disposing the biomedical waste through an alternative called as pyrolysis and also land mining, Your Lordship. And through that, the hazardous fumes will be.
Are there any fundamental freedoms what we have to them?
They have fundamental right, right to life and right to free environment.
So do they have a 19(1)(g), what our co-counsel said? Whether Denmark or Philippines or Norway or China, do they have fundamental freedom what we have?
Your Lordship, even though they do not have, we can see how forward they are in their
So
technologies.
when we have fundamental freedom, they don't have. Then let them use any form of a technology. Why you are bringing their technology to declare our laws are unconstitutional?
Much obliged, Your Lordship. We are not coming to that point, Your Lordship. What we are trying to say is, due to this incinerator and due to the mechanism used in our country, crores of people are getting carcinogenic cells which cause cancers and other type of diseases which is harmful for the people living around, Your Lordship. And also, Your Lordship, so far the honorable respondents of Union of Yavana has not taken any statistics or survey how the biomedical waste incinerators are affecting the human life, Your Lordship, because the incinerator fumes provide polychlorinated dibenzoparadoxins and also polychlorinated biphenyls, which is hazardous to the respiratory system, Your Lordship. And also due to this, many adults and also children around the space has been calculated that they have dioxin presence in their blood, Your Lordship. And also these calculations have been made according to the Central Pollution Control Board Audit Report 2020, Your Lordship. And according to that audit report of 2020 provided by the Central Board itself, it states that nearly 60,000 of biomedical waste is being disposed, Your Lordship. And due to that, fumes are being released.
Is it a state subject or union subject?
Much obliged, Your Lordship. Your Lordship, this is a union subject. According to Schedule 7 of the Indian Constitution, according to Union List under Entry 13, it is a duty of the Union government to implement or to attend the international conventions, Your Lordship. Here we have attended International Convention of Rio Declarations for this biomedical waste hazards.
Is it not a subject comes under health?
It also comes under health.
Public health is comes under which list of the Rwanda Constitution?
Public health, sanitation, hospitals are under which list? That's what our brother judges ask.
Yes, union list or concurrent list or in the state list.
Apologies, Your Lordship. One moment. It is in the compendium.
Yes.
Much obliged.
Let your co-counsel search it and submit it.
Much obliged.
You can proceed.
Yes, Counsel. The second point you have mentioned about Article 51A. Is
Indeed,
it
Your
a duty of the individuals or citizens to perform the segregation, or is it a duty of the state council?
Your Lordship, the entire liability coming upon the second lacuna of the 2016 rules, Your Lordship. The duty is imposed upon the state according to Rule 16 of the 2016 rules, but the liability has been delegated to the employer, that is the occupier of the CBDT, Your Lordship. Therefore, they have transferred the duty itself to the other person who is doing an occupier, that is the central.
Right. So with respect to biomedical, you brought a rule from Rio Declaration. Which principle of Rio Declaration speaks about classification of biomedical waste, Council?
It speaks about the hazardous management, Your Lordship. Hazardous management.
Which rule of Rio Declaration? Which year?
Apology, Lordship. It has been provided in the compendium. Your Lordship, to the first question, Your Lordship, it comes under public health, comes under the state list.
Entry 6, leave it. I am asking international. Entry 6 of list 2. So. Okay, if you are searching,
Your Lordship, it is in principle number 16, Your Lordship.
16.
And it has been provided in the compendium, Your Lordship, under page number 504.
You read out the content of principle 16 doesn't speak anything of classification of biomedical waste.
It talks about environmental protection, Your Lordship. It includes
Principle 16 of Rio Declaration, 1992. It's a polluter pay principle. It doesn't say any classification. Read out.
apologies, Your Lordship.
Economic instruments should be used to quantify the damages. Okay, leave it to your council. Already you have passed your time.
Your Lordship, and moving on to the same issue, Your Lordship, as the authorities itself are delegating their duty towards the operator here, there is no liability posed upon the prescribed authorities itself. Here, the primary object of the biomedical rules is to make sure that the biomedical wastes are being disposed properly, and that is the reason why there have been the biomedical waste has been categorized into 4 categories, that is yellow waste, white waste and so on, and also each has been provided with a type of segregation. And as there is autoclaving also, Your Lordship, basically the yellow waste are regarding the human parts. It can be used with an alternative method also, but instead of using that, they are not, but according to the rules, yellow waste are being incinerated. The guidelines has been provided that the yellow waste has to be incinerated or land mined, or also they has to be done according to the pyrolysis method, Your Lordship.
By whom?
It has to be done.
Ministry, is it by a board?
Your Lordship, that is the lacuna present here. It has to be, everything has to be done according to, by the central pollution. It has to be done by the occupier. That is the person who is in charge.
Occupier got the permission to run the same with the whose permission?
With the SPCB. Again coming to that, the SPCB is not providing...
Have you approached SPCB for non-compliance of the rule whichever made by the central government by referring the PMWR 2016?
Your Lordship, the constitutional, they do not have any liability here, even to give a complaint. They have only the duty, Your Lordship. The liability according to Rule 17 of the biomedical rules says that the liability shall be imposed upon the occupier or the person who is the authority of the same CBTD if there is a violation of the rules. If there is a lack of proper implementation or any other such, we have to approach the Honorable Supreme Court.
Lack of implementation is a ground for you to challenge the
definitely
constitutionality
not.
and declare us ultra vires.
Definitely not, Your Lordship. That is a secondary issue. The first issue is regarding the incinerator.
PMWR rules, what all local remedies you are conferred with?
Your Lordship, we have not approached any local authority so far because we haven't. Because here the entire CPCB. Definitely not, Your Lordship. Definitely not. Apologies for...
Which prevents you to not to approach these two levels of PCP and local bodies who care to allow the people to engage in the same business called manual scavenging?
Your Lordship, the reason why we are approaching the Honorable Supreme Court is already the SPCB is not complying with their rules, because according to the same CPCB report,
You didn't approach the High Court of same state.
Your Lordship, there is a violation of fundamental rights guaranteed under Article 21, Your Lordship, right to life and right to healthy environment.
Okay, what the last issue? NHRC.
NHRC been dealt. Yes, Your Lordship.
Oh, sum up. Thank you.
Much obliged, Your Lordship. Your Lordship, according to the first issue, the PEMSAR Act of 2013 is not constitutionally valid. And secondly, Your Lordship, the international conventions which has to be adhered by the Honorable Union of Yavana to prohibit the manual scavenging and also to protect the citizen of non-citizen entering into Yavana has not been implemented properly. And also, Your Lordship, thirdly, the compensation has to be provided by the state for all the dependents of the deceased, Your Lordship, on the basis of human rights jurisprudence and also compensatory jurisprudence, as there is violation of fundamental rights of Article 14 and Article 21. And lastly, Your Lordship, regarding the biomedical waste rules, there is a lack of implementation. Also, there is a lacuna in the law present, and therefore, Your Lordship, it does not fulfill the constitutional mandates, and therefore, the court has to direct the SPCBs to take to alternative measures, and also alternative technologies has to be used instead of incinerator in biotechnology rules, Your Lordship. Council seeks permission.
Last and final clarification.
Much obliged,
Have you
Lordship.
come across any decisions which are given by the same constitutional court to say, okay, follow 1, 2, 3, 4? Because you are asking us to give a guideline, state pollution control has to follow this and that. Could you brought any situation where the constitutional court listed what all has to be followed by any enforcement mechanism, council?
Much obliged, Your Lordship. Council seeks to rely upon the case of Aryavat Foundation versus MS Vapi Green Environmental Limited, which has been provided in the memorial of petitioner in page number 30, Your Lordship. According to the Honorable Supreme Court, observed that the regulatory regime in the form of SPCB has not been effective as expected as in the Honorable Court in the matter of Takita Katara versus Rajendra Singh Bandari. This is partly on account of appointments not being made up to mark, as well as the absence of audit report of performance and monitoring mechanism. This need to be remedied in the light of performance audit and study by an expert committee. Therefore, according to the same,
PMWR rules made referring which law counts?
by BMW, it has been implemented according to Environmental Protection Act, Your Lordship, under the section of apologies. One moment, Your Lordship. It has been provided that according to section 5, 6 and
Okay, you can present during your rebuttal. Thank you.
Much obliged. Council seeks permission to state the prayers.
Yes. Already you said no all for prayer.
Okay, much obliged, Your Lordship. Much obliged, Your Lordship. Good day, Your Lordship. Thank you.
No, you received the question.
Your Lordships, the Council seeks permission to collectively address the bench as Your Lordships. Much obliged, Your Lordships. Your Lordships, the Council is appearing for the respondent, the Union of Yavana, Your Lordships. Your Lordships, the Council seeks permission to submit the bench of compendium for Your Lordships' perusal, Your Lordships.
So you are the Attorney General representing the Union of Ravana.
Indeed, yes, Your Lordships.
Yes, Attorney General, you can proceed.
Much obliged, Your Lordships. Your Lordships, in the light of petitioner's arguments, there are 4 issues that have been raised against us, Your Lordships. Your Lordships, the first 2 issues, whether the prohibition of employment of manual scavengers and the Rehabilitation Act 2013 is constitutionally valid, and the second, whether government of Yavana has complied with all its international commitments has been dealt by me, Your Lordships. And the other 2 issues, whether the dependents of the deceased were entitled for the compensation, and whether the biomedical waste disposal regulations are fulfilling the constitutional mandates will be dealt by my co-counsel, Your Lordships. Much obliged, Your Lordships. Your Lordships, the Council seeks permission to proceed with the arguments, Your Lordships. Much obliged, Your Lordships. Your Lordships, on dealing with the first issue, whether the prohibition of employment as manual scavenger act has been constitutionally valid, Your Lordships, the petitioner has submitted various allegations against us against us, Your Lordships. Your Lordships, the legislative intent of the Act, PMSR Act 2013, has been taken into account, Your Lordships, first. Your Lordships, there is promoting the fraternity and assuring the dignity is in our preamble itself, Your Lordships. And also, Your Lordships, there is an historical injustice and the dignity that has been experienced by the manual scavengers here, Your Lordships. So, in order to address all this, the government has came up with a new act, Your Lordships, where already an existing act in 1993 which prohibits the dry latrines, Your Lordships. The existing act which is not providing a sufficient remedy, the government has came up with a new act, Your Lordships. Your Lordships, the Council has been relying on the RMDC versus Union of India case, Your Lordships. AIR 1957 SC 628, which has been in the compendium. If Your Lordships directing, the Council would like to guide Your Lordships to the compendium sticky note number 44, Your Lordships. Page number 2, Your Lordships, first para, Your Lordships. Sure. Much obliged, Your Lordships. Much obliged, Your Lordships. Your Lordships, it will be on interpreting a statute, Your Lordships, it will be legitimate to take into account the history of the legislation, Your Lordships, and also the title and the preamble to it, Your Lordships. Your Lordships, where already an existing act which is not providing a sufficient remedy, Your Lordships, that's why the government has came up with a new act in order to prohibit the manual scavengers. Your Lordships, the mischief for which the present statute has been in order to give the remedy for the 1993 Act, Your Lordships. Your Lordships, manual scavenging is banned, Your Lordships, and it's not practiced. As the learned opposite counsel has said that it has been practiced now, but it has banned, Your Lordships. As per the Act, it is banned, and it has not been practiced, Your Lordships. That's why our Honorable Prime Minister has also stated in the during 15th August 2022 that it has been banned, Your Lordships, and every manual scavenger has been completely eradicated from the Union of Yavana, Your Lordships. Your Lordships, the council, the learned opposite council, is relying on section 2(1)(d) and 2(1)(g) of the Act, Your Lordships, which is ambiguous, but the Act which says in the sections, the provisions of the sections were very clear about the manual scavengers and also the hazardous cleaning, Your Lordships. Your Lordships, the Act where mentioned that the protective gears and the safety devices. Your Lordships, we have came up with the manual scavengers rules 2000.
Whether the practice of manual scavenging is eradicated or it is regulated.
Your Lordships, it is regulated, Your Lordships.
Just a minute back you said it is completely banned.
Your Lordships,
Why you are misleading the court?
Your Lordships, the council seeks apologies, Your Lordships. The manual scavenging has not been practiced, Your Lordships, because we are using mechanical equipments, Your Lordships, for the manual scavenging. Your Lordships?
Dry latrine alone was banned. Even manual scavengers are being used.
Indeed, no, Your Lordships. Your Lordships, coming to the definition of manual scavenging, where the human excreta will be handled by hand, it is only the manual scavenging. It has not been practiced anywhere, Your Lordships.
From the day of enactment until 2022, there was no death in furtherance of engagement of human beings in the cleaning of the manual scavenging.
Your Lords, we have a sufficient data, Your Lordships, and Your Lordships, the death has been happening because of hazardous cleaning, Your Lordships, that is in the sewers and the septic tanks, Your Lordships, but not because of the manual scavenging, Your Lordships. Much obliged, Your Lordships. Lordships, in the section 2(1) subclass D and 2(1) subclass G, they have been stated it is an ambiguous, but in rule 4 of the MS rules, which has been enacted by the same government in the 2013, Your Lordships, where it has been clearly stated, Your Lordships.
Which constitutional article authorized you government to make a rule after 50 years of Indian Republic of Yavana?
Your Lordships, have been made the rule as per the Act, Your Lordships. The Act has the provision. Your Lordships.
Constitutional provisions permit you to make a rule after 50 years of the Republic of Yavana.
Your Lordships, the society is evolving, Your Lordships, and the government is working on the welfare of the public, Your Lordships.
Please quote the constitutional provision under which your Act is based upon.
Your Lordships, it is based for the protection of people, and it is given in the concurrent list, entry number 24, conditions of work, Your Lordships. In the concurrent list, where the Parliament has the sufficient power to legislate on the subject, Your Lordships.
You to brought a law after 2013, Attorney General.
Much apology, Your Lordships.
Made you to law after 2000 only. Wasn't there any practice prior to that? Prior 2013?
Your Lordship, it was there, but in the Civil Liberties Act of 1955, where it has been again in the rule, Section 7A has banning the manual scavenging, Your Lordships. And also in 1993, we have abolished this manual scavenging, that is prohibition of employment in the dry latrines, manual scavenging from the dry latrines, Your Lordships. And in furtherance to that, these two acts has not sufficiently has been enough for the remedy, Your Lordships, not given sufficient remedy, Your Lordships, for the manual scavenging. That's why we have enacted.
Petitioner side, they also feel that this now act has been enacted by use not so sufficient, so that they are challenging it as unconstitutional.
Your Lordships, the council would submit that the petitioner's contention was that, but the council for the respondent has not been submitting that it is the it is not at all enough. It is more than enough, Your Lordships. The council will submit.
So now was made only in furtherance of fulfilling the division and distribution of legislative power, or to respond to the international commitment.
Your Lordships, we have enacted only because the government is government wants to take care of the people, Your Lordships. That's why we are enacting, because it's not for the international commitments at all, Your Lordships. It is for, we have here to abide by the international conventions also, we are obeying also. But still, government has been taking care of the welfare, Your Lordships. We want the people to be happy. We want the people to have a healthier life, Your Lordships. That's why we have enacted this law.
Council,
Yes, Your Lordships.
one of the major ground to challenge the act is inadequacy of provision.
Yes.
As
Yes,
you
Your
are
Lordship.
representing the Union of Ravana, would you please assist the court by quoting any provisions of any decisions of this court that the inadequacy of the provision is a ground to set a law ultra vires? No, let him. Is it a ground or not? Let him say.
Your Lordships, inadequacy of law, Your Lordships.
Yes, because that was the major ground of your other side. When they were arguing, they said that there are inadequate provisions in the act.
Your Lordships, if there are inadequacies, Your Lordships, the petitioner can contend that the act can be amended, Your Lordships. The sufficient provisions can be added with the amendments. But letting the whole act unconstitutional is again making the manual scavengers to be letting them free. That's why it will give more discrimination. It will be diluting the very object of the act, where the discrimination will be again perpetuates, Your Lordships. If we are
Wants to clarify is to state whether inadequacy is not a ground to invalidate a law, or it is a ground to validate a law. You are supposed to support.
Is it a
your
ground to
argument.
inadequacy is a ground to challenge the law?
Your Lordships, the council is not aware of any provisions, Your Lordships, but the council will submit.
Any pronouncement of this court?
Your Lordships,
Any high court of Ravana state?
Your Lordships, I take much apologies, Your Lordships. The council is not aware of any precedents regarding the matter that Your Lordship says, Your Lordships.
One more data I used to get from the Union of Ravana.
Yes, Your Lordships.
You said that this historical injustice caused to a section of people.
Yes, Your Lordships.
Could you please say how many people have engaged in manual scavenging in your country before you bring this law?
Your Lordships, we have a data, Your Lordships. Let me go with the.
Have you referred to Safai Karamchari and Dollar case?
Yes, Your Lordships.
It was
More than a lakh.
Previously, who represented Ravana state has reported before this court 12 lakhs people all over the Ravana state. In Safai Karamchari state, when this bench was hearing the case, one of council
Yes, Your
represented
Lordships.
Ravana has told that there are 12 lakhs people in Ravana state engaged in manual scavenging.
Your Lordships, 12 lakhs people are there. By enacting this act, Your Lordships, many of the people have left the job. Many of the people are not practicing manual scavenging, Your Lordships. That's why while taking the survey in 2013 and also in 2018 by the government of Yavana, there we have identified only 58,098 people, Your Lordships. That's why we have rehabilitated, Your Lordships. With
Scavenging is a livelihood of many of a sect of people.
Your Lordships,
Have you provided any alternative livelihood to them by prohibiting this manual scavenging?
Your Lordships, with the virtue of Section 13 and 16, Your Lordships, we have been rehabilitating.
Rehabilitation purposes you have done for
Yes, Your Lordships. Your Lordships, one cash assistance, Your Lordships, one-time cash assistance of 40,000, Your Lordships, and we have increased the capital subsidy that has been giving to the loan giving to the manual scavengers. We have increased from 3.25 lakhs to 5 lakhs, Your Lordships, now, and we have been given the residential plots to them, Your Lordships, and also for alternate livelihood, we have been imparting 2 years of skill training program with 3,000 stipend, Your Lordships. Yes. Much obliged, Your Lordships. Your Lordships, as the petitioner has contended that it was unambiguous, is ambiguous, but it is not unambiguous. It is not ambiguous because Rule 4 it clearly states that the employer shall provide. So employer should provide, Your Lordships, all the safety gears, safety devices, and the protective gears, Your Lordships.
It doesn't say how many or how much they have to give. That's what they are contending.
Your Lordships, the rule says it is by the safety devices and protective gears of the following, but not limited, including but not limited, Your Lordships. Including in the sense all the 44 items has to be given.
Whenever the same provisions not complied with, what recourse you as a state can initiate against them?
Your Lordships, if a person is not using the protective gears and they are employing as a manual scavenger, we have a penal provisions under section 7 and 9, Your
Do you
Lordships.
have any data how many of them prosecuted from the day one of the implementation of the act?
Your Lordships, Your Lordships, I don't have data, Your Lordships, but the
You
problem.
are representing the government.
Yes,
I'm
Your
not
Lord.
asking
Your
you as a
Lordships, there
council.
was-
You are a state.
Your Lordships, there is no one convicted with this act, Your Lordships, because if the
Is it
death.
wrong for them to simply say because you made a law, then you are simply sleeping. That is the reason all people are literally using. Then let them sacrifice.
Your Lordships, Your Lordships, the scene that we have seen and also in the instant case is death has been caused, Your Lordships, that is by negligence. If they have employed, if they have employed and it is came to the notice of the government, then we can impose these penal provisions. But the death has been happened. That's why we have invoked these IPC sections, Your Lordships. Death happened, Your Lordships.
PC section were there before the enactment of the same.
Yes, Your Lordships. But
What we are asking, since you were not comply with the different provisions of Ivana Penal Code, you were compelled to exhaust the provisions which were there in the concurrent list, and you made a law.
Indeed,
where
yes,
you
sir.
made a loophole to escape all the service providers. Then whoever wants, that's what they are bringing, the non-compliance as well as ambiguity within the legislation.
Indeed,
If at
no.
all you would have mentioned a figure, they would have strictly complied with. You can have a easy H code.
indeed, no, Lordships. Your Lordships, protective gears and the safety devices has been mentioned, then they have to use, Your Lordships. Much obliged, Your Lordships. Your Lordships, as the petitioner claims,
What is the relevance of your 1.3.2 for this discussion council? Page number 16. Performance of Swachh Ivana.
Your Lordships, the government has taken many measures. Government has taken various measures in order to curb the menace of the manuals.
You yourself admitted you don't have a data. Then what's the point in saying you brought these many measures?
Your
Is it
Lordships.
only to boost yourself?
No, Your
That's
Lordships.
what you are doing.
Your Lordships, in the Act itself, we have said that the government will take sufficient measures to convert the insanitary latrines into a sanitary latrine. So, by the program of Swachh Ivana, we have been constructing the sanitary latrines, Your Lordships, where we have achieved 100% of sanitary latrines in the country of Ivana, Your Lordships. Much obliged, Your Lordships. Your Lordships, if your Lordships are convinced with issue number 1, the Council seeks permission to move with issue number 2.
We are not convinced, you proceed. Don't ask whether we convinced or not. Good.
Your Lordships, the Council will convince if any other questions will be posting on me, Your Lordships. Much obliged, Your Lordships. Your Lordships, the second issue what the petitioner has posed was whether the government has complied with international commitments, Your Lordships. Your Lordships, the country of Ivana is a dualistic country, Your Lordships, where the domestic laws will prevail over the international laws, Your Lordships. Where in the Jolly George versus Bank of Cochin, also the Honorable Supreme Court has held that domestic laws will prevail over international laws, Your Lordships. Though country of Ivana does not want, though the country of Ivana has not been mandated to obey the international laws, but the country of Ivana has complied with all international conventions, Your Lordships. As the petitioner counsel, as the learned opposite counsel has stated with the article 23 subclass 3 of UDHR and other articles of ICCPR and ICSCR, your lordships, through the act we have been eradicated. We have eradicated the manual scavenging and also we have been rehabilitated them, your lordships. Lordships, with section 13 and 16 we have the rehabilitation procedures, your lordships. So ILO Convention 111, which is again speaking about the ILO Convention 111, which is again speaking about the avoiding discrimination in the workplaces, and also 155 and 187, which has to bring the occupational and occupational safety and the conditions for work, your lordships. Again, we are fulfilling the same mandates by using the PMSR Act, your lordships. We have been protecting them with the safety devices and protective gears.
Are they covered under the Factories Act Council?
No, your lordships.
Then which made them to part occupational safety and other thing?
Your lordships, for PMS, for manual scavengers, your
Yes.
lordships. Your lordships, for manual scavengers, it is the welfare of the people, your lordships. So it is not an option that the government has to obey all these things. But
which measure is responsible? Are they properly followed the mandate whichever ILO guideline says?
your lordships,
Under the BMW Act,
Yes,
under the 2013 Act,
yes, your lordships.
what is the enforcement machinery to verify all these safeguard measures are followed or not?
Your lordships, the domestic law which has to satisfy the international law. So the domestic law which has to satisfy international law. So the domestic law satisfy it.
Provisions of its domestic law.
Your lordships, PMSR Act, we have the provision. Lordships, rule subclass 4, we have been given protective gears, safety devices, and also the your lordships, and also we have the council submits that the government of Yavana has been providing workshops, skill trainings, and also the seminar programs for using the safety devices also, your lordships. As the petitioner has contended that they don't know how to use, we have conducted the seminars and the workshops also, your lordships. Your lordships, and also for biomedical waste management, also we have been complying with Stockholm Convention and also the Basel Convention on persistent organic pollutants, your lordship, of transboundary movement of hazardous waste, your lordships, by enacting the hazardous and other waste management regulation rules and biomedical waste management rules 2016, your lordships. Your lordships, hence it is humbly submitted before the Honorable Court of Yavana that government of Yavana has been complying with all its international commitments, your lordships. If your lordships are convinced with first and second issue, my co-counsel will be dealing.
Council, we have to say our opinion whether we are convinced. You convince your conscience first.
Your lordships?
You are conscious. You have to convince your conscience.
Yes, definitely yes, your lordship. Very.
Do not worry about the bench.
Your lordships, ultimately the degree I will provide by the lordships, your lordship.
We are not a civil court to provide a degree. We are a constitutional bench.
Your lordships, we much obliged, your lordships.
Two more clarifications.
Sure,
Since
Your
you have a lot more time. So you made a mention about India is following a dualism,
Yes, Your
right?
Lordships.
You
Yes, Your
brought a beautiful case called Jolly George Verghese versus Bank of Kochi.
Yes, your lordships.
Whether state of Yavana made any law allowing the people to enjoy human rights in Yavana, or you have any different compartmental approach?
Your lordships, our fundamental rights is very organic, your lordships. Part 3 of our fundamental rights is very organic, your lordships. Because of this universal declaration of human rights, only we have inculcated many of the human rights into our fundamental rights, your lordships. Your lordships, and also it has been stated by the Honorable Court itself that it is organic so that we can add more and more rights which been evolving in the society, your lordships.
Second one is you made a mention about dualism. Is it applicable to all form of law which international community adopted, or it is not applicable some content like
Your
trade rules, biotechnology, climate change, and biodiversity?
Your lordships, the council was not aware, your lordships, but the special conventions has to be obeyed only by ratifying and also by ratifying the international convention and by enacting the domestic laws.
Then third interesting question, page number 2, you brought a Basel Convention.
Yes, your lordships.
Whether this subject speak anything about transboundary movements brought biomedical waste from other country to India, or Yavanas to other country, gentlemen?
Your lordships, the Moot position, in the Moot proposition, it was said that there will be there is a suspicious movement of containers which will be taking, which the GHS has bound. So, in order to clarify that thing, Your Lordships, we have bounded by the Basel Convention where the no import was allowed, Your Lordships. No import of biomedical waste has been allowed in country of Yavana, Your Lordships.
What is the mechanism you are not provided for the purpose of regulating these movement of goods referring your Customs Act? Do you have any mechanism?
Your Lordships, we have implemented the biomedical waste management rules, Your Lordships, only with the, Your Lordships, hazardous and other waste, transboundary movement and management rules, 2016 we have enacted, Your Lordships, where we have been deputing the central authority. We have been deputing the central authority to look over this, and in that also, in that rules also, we have been clearly stated that
According to your PMWR rules 2016, which ministry is responsible to classify and enforce it?
Your Lordships, Ministry of Environment, Forest and Climate Change, Your Lordships.
Is it only ministry? How many schedules you have? Which ministry is given a responsibility to classify what all different kinds of red, yellow, orange, blue?
Your Lordships,
We have a Ministry of Public Health in our country?
Your Lordships, we have Ministry of Health and Family Welfare, Your Lordships.
Yes.
Are
Those
they
department-
responsible?
Your Lordships, the council was not aware, and the third and fourth issue will be dealt by co-counsel. She will clarify the Your Lordships doubts regarding this biomedical waste, Your Lordships.
This bench would like to draw a distinction between the constitutional liability of the state and the contractual liability of an individual. You have referred to the Jolly Judge Verghese versus State of Cochin.
Yes,
It
Your
was a
Lordships.
case where an individual has borrowed an amount who could not repay it.
Yes, Your
It's a
Lordships.
contractual liability of an individual.
Yes, Your Lordships.
And no question of constitutional liability or constitutional morality of a state involved in that decision.
Yes, Your
That's
Lordships.
the distinction which the bench would like to make it now itself.
Yes, Your Lordships.
Is not going to help you.
Yes, counsel. So you gave extra time to your co-counsel.
That's your co-counsel may have.
Much obliged, Your Lordships. Sure.
Co-counsel gave extra 5 minutes to you too.
You can add.
కొంచెం
Court officer can help. Court officer can help her.
Your
Counsel
Lordships,
is very
am I-
anxious to argue, but court officer has to help her.
Your Lordships, issue number 3 as well issue number 4 will be dealt by the council number 2, Your Lordships. Issue number 3 is that whether the dependents of the deceased are entitled to any kinds of compensation, Your Lordships. Your Lordships, the council would like to clarify the bench that there is no provisions regarding compensation has been made in this particular act, Your Lordships. We would like to clarify that why the compensation mechanism was not being made is because of that. If compensation has been given to the persons who have been deceased, the person, the manual scavenger, would be motivated irrespective of his life due to some economical necessity. He himself may come forward to do such manual scavenging, Your Lordships. So, to prohibit such actions, the compensation has not been provided, Your Lordships. Indeed, we had provided with the other measures of rehabilitation, Your Lordships, which has been set under Section 13 as well as Section 16, Your Lordships. The both things deals with the rehabilitations given to the manual scavengers, Your Lordships. Your Lordships, the second thing is that the second submission which we would like to make is that
Which doesn't talk about the
Compensation.
yes, Your Lordships.
case of necessity, whether this court can give a compensation to the
Yes, Your Lordship. Supreme Court has been entitled to pass any directions under Article 140.
And the petitioners have also not approached this court under the provisions of the Act. Their contention is this court has got power under Article 32 to extend the compensatory jurisprudence upon the victims.
Yes, Your Lordships. The council would like to state that there is no contractual obligation between the state as well as his employers, Your Lordships. From the facts, it is very much evident that it is a
council, suppose it is a negligence on the part of the government, whether this court has the power to pass a compensation.
Your Lordships, if it is the negligence on the part of the government, if the government has employed such employers, then the government would be liable to pay compensation. But the government has bounded to this Honorable Supreme Court's judgment in the case of Safai Karamchari versus Union of India, which is a landmark judgment, and in various judgments such as Delhi Jal Board. In those cases, Your Lordships, the employers was employed by the government. So, this Honorable Supreme Court has mandated us to provide compensation where we are bounded thereto. But here, in this particular case, Your Lordships, this GHS, Global Health Security, it is a private organization, it is a multinational company which has been employing such employers, Your Lordships. Therefore, in this particular state, there arises no obligation, no contractual obligations on the part of the state in order to provide compensation, Your Lordship. It is very much clear that there is no contractual obligations arises on the part of the employers as well as the state, Your Lordships. If the compensation has to be given, then the onus should be shifted upon the private company who employed them. How the government could be made liable in this case to provide compensations, Your Lordships. This is the arguments which we want to take up, Your Lordships.
What do you think about doctrine of parent patriae?
Your Lordships.
Doctrine of parents patriae.
Yes, Your Lordships.
As per the doctrine, what is the liability of the government? You are saying that only liability arises by the contractual liability arises.
Your Lordships, parents patriae is a principle that the person, the country must protect its own resources, persons, or its own citizens. Everything comes under parents patriae, Your Lordships. In order to protect them, the legislation has been made, Your Lordships. The legislation has been made. It is clear, but here in this case, Your Lordships, there is no lack of parents patriae. We have complied with the legislation. We have come out with the legislation to help out, Your Lordships.
Welfare state, what is the role of the government?
Your Lordships, we agree that it is a welfare state where where in many cases the compensation has been provided. But here there is a no wrong on the part of the government. As a welfare state, only we have enacted such legislations, Your Lordships.
Counsel,
Yes,
in
Your
which
Lordships.
case doctrine of parents patriae was brought by this bench?
In which case, Your Lordships?
Is it a Ivana jurisprudence or is it a foreign jurisprudence?
Your Lordships, this particular thing has been, I lack the knowledge on that part, Your Lordships.
On whose control GHIAS is functioning in Ivana?
Your Lords, it is a multinational company, Your Lordships.
Run its business in Ivana.
Your Lordships, in order to run its business in Ivana, it was the Government of India who authorized that, Your Lordships.
Are you appearing for Government of India?
I will take back my word, Your Lordships, Government of Ivana.
Are you appearing for Government of Ivana?
Yes, Your Lordships, we are appearing
Then
for...
who permit them to come and carry all business on behalf of you as your servant or substitute?
Your Lordships, we just give the license, Your Lordship. That doesn't mean we authorize them.
As our brother counsel said, after giving a license, you are ready to wash. So you are not ready to act as a parent.
No, Your Lordships, we have provided with the provisions, Your Lordships. Various committees has been made, Your Lordships. Under the part of the Union of Ivana, Your Lordships. Your Lordships, the duty of the committee is to inspect, Your Lordships, where the Ivana has been inspecting all such, inspecting and efficiently working, Your Lordships. This particular event has happened, Your Lordships. If the, Your Lordships, if manual scavenging has to be done with any kinds of exceptions which has been stated in the legislation, Your Lordships, it is that the person who are employing, that is any agency who are employing the manual scavenger, should obtain an consent from the CEO of the local authority, CEO of the local authority, Your Lordships. Here, this GHS lacked to obtain such an consent from the CEO, Lordships.
Have you initiated any measures to delicense them or blacklist them?
Your Lordships, the prima facie trial has been going, Your Lordships, where they have been booked under 304, 107 and 109 of Yavanian Penal Code. this has been the steps have been taken by the government.
You are waiting for the outcome of the court. Thereafter, you will initiate the proceedings against the company.
Yes, Your Lordships. If it is proved, then the actions against the company would be taken by the government of Yavana.
One more limb of argument was that the petitioners approached the MNC, which was the employers of those manual scavengers.
I beg your pardon, Your Lordships.
I mean, that company which engaged the manual scavengers
Yes, Your Lordships.
is the responsible, and they are accountable and liable for the.
Yes, Your Lordships. Yes, Your Lordships. The government is nowhere liable to pay compensation, Your Lordships.
They have to first of all approach that company, GIHA.
GHS here. Your
GHS.
Lordships, there arises the contractual obligations, Your Lordships. As our learned respondent council stated.
First of all, they must exhaust that remedy.
Yes, Your Lordships.
If the MNC failed, I mean the GHC,
GHS failed.
GHS failed, state will take the responsibility.
Your Lordships, it doesn't mean that the state will take responsibility, Your Lordships. If in case the Supreme Court direct us, we are bound by that, Your Lordships.
The government is sticking to the policy of polluter pays principle.
Your Lordships, it doesn't come under the polluters pay principle, Your Lordships. This particular manual scavenging doesn't come under the principle of polluters pay principle, Your Lordships. Your Lordships, the learned opponent council state that vicarious liability of the state, Your Lordships. Your Lordships, the vicarious liability of the state will be arising only in the three categories. That is the Your Lordships, in three cases only the vicarious liability will be taken place. That is principal agent or master servant or an independent contractor, Your Lordships. Only under three cases the vicarious liability could be taken place, Your Lordships. But here the government doesn't comply with all the three categories, Your Lordships. Therefore, the vicarious liability is not applicable in this particular case, Your Lordships.
Council, is it a competent court to initiate a proceedings for want of vicarious liability? Are there any alternative forum?
Your Lordships, this is not the appropriate, but the petitioner.
Mention as if there are various grounds. You could happily say this is not a forum to discuss. Which preventive doesn't?
Your Lordships, in order to give the clarifications.
Second, as the other council beautifully asked, polluter pay principle.
Yes, Your Lordships.
Your own council had discussed, we the committed Yavana ready to transform all international law into domestic.
Yes, Your Lordships.
Then which prevent you not to accept you as a polluter, then you are not ready to pay? Because there is a loss of life. You committed to create a law, you created a law
Your
with the
Lord-
loopholes. Then instead of accepting responsibility, you simply leave it to GSS. Then you are ready to say we are starting other provisions referring Yavana Penal Code.
Your
Why you are
Lordships-
not ready to accept as polluter?
Your Lordships, this polluter principle has been dealing with the environmental law issues.
It's not an environment issue.
Your
What is the
Lordships,
definition for Environment Council?
Your Lordships,
Yavana made any law for environmental protection.
Yes,
What is
Your
the
Lordships.
definition for environment?
Your Lordships, Environment Protection Act has been implemented, has been enacted. I will take back my word, Your Lordships. Enacted in the Parliament of Yavana, Your Lordships, where the environment consists of all the surroundings, human beings, resources, everything comes under the
These are learned council definition.
Yes,
I
yeah.
want a definition from Environmental Protection Act 1986 as you had mentioned. Do
Yeah.
we have or don't we?
Your Lords, we do have the definition of environmental law. If
researcher can help you to read?
yes, Your Lordships.
Yes. Because you are happily saying this is not an environmental issue.
Your Lordships, environment includes water, air and land and the interrelationships which exist among the between water, air and land and human beings, other living creatures, plants, microorganisms and property, where section 2A of the...
Whether these human beings, whoever engage in the manual scavenging, are they human being or any aliens who came from outside?
Your Lordships, we agree that they are the human beings, Your Lordships, but in the...
Then why you are not ready to pay damages for them as our present council asked?
Your Lordships,
They said they are not the parents.
Your Lordships, on a broader scope, the environment includes the natural resources.
Broader scope. You as the student of law, you are reading a definition.
Yes, yes, Your
There's a
Lordships.
construction.
Yes,
Why
Your
you are
Lordships.
bringing something from outside? You only made a law, no?
Yes,
When
Your
you made a
Lordships.
law, you beautifully included human beings.
Yes, Your
Which
Lordships.
prevent you not to pay damages as and when your license holder killed the people because of non-compliance of 2013 Act.
Your Lordships, human beings has been included, Your Lordships, if they have been affected by any kind of pollutions, Your Lordships. But here, no.
Purpose of the
The-
act is to eradicate manual scavenging.
Yes, Your Lordships.
In spite of the act, there was a death
Yes, Your Lordships.
because of your inefficiency in monitoring the same.
Indeed, no, Your Lordships.
The,
Because of the officials, those who have not inspected.
No, they made a beautiful law, ma'am. The people who are in not ready to implement. That's what she was saying, not indeed.
you know, the
Yeah.
Why not you shoulder your responsibility in paying the compensation? 4 lives have been taken away.
Your Lordships, as the,
No,
as
I could recollect the statement you began our argument.
Yes,
the
Your-
government of Ivana wants to prevent. So
Yes,
if
Your
we
Lordships.
provide a compensation, many people will come and die.
Yes, Your Lordships. Your Lordships, no, indeed, no, Your Lord. My sincere apologize, Your Lordships. Indeed, no, Your Lordships. The compensation has been, a compensation is no provision in this particular law, and there is a this that has a.
As our sister council beautifully, judge mentioned, is it not a fault on your side? That's what the learned petitioner council said. The non-availability of provisions is a ground to declare the same law as an unconstitutional.
No, Your Lordships. Inadequacy. If there is any inadequacy, there.
Because you are giving only 1 year term period
Your Lord, for
violation.
Your Lordships, those are the penal provisions which has been provided,
That's
Your
what.
Lordships.
Why instead of penal provision, which prevent you to not to include a portion, whoever dies during the business, they can be quantified with some 20 lakhs or 50 lakhs.
Then what about the victim compensation?
Your Lordships, yes, Your Lordships, so victim compensation, if that has been provided, Your Lordships, the person will be, the person who may himself will waive off his fundamental right, Your Lordships, because due to some
Council,
The employer permitted the manual scavengers to do the work.
yes, Your Lordships,
There is no permission by the employer, there will not be any loss of life.
yes, Your Lordships,
There was a violation of the penal provision.
but they nowhere force the persons to work, Your Lordships.
Providing compensation, how can you say that the victim will come and do the work only for the compensation provided under the act?
Your Lordships, due to economical necessity, he may come, Your Lordships, so that only we prevent the.
What does your state has done for the person who are suffering economically and so
We have rehabilitated, Your Lordships.
then you fail in your rehabilitation, so only they have forced to do the work.
Your Lord,
You are supposed to take your responsibility for not rehabilitating properly.
Your Lordships, indeed, Your Lordships, we have rehabilitated them properly, Your Lordships. Even, Your Lordships, I would like to quote Thomas Hobbes say that the human mind is evil in nature.
This is the exploitation of right by the employer against the human norm, those socially backward or economically backward.
Your Lordships, they come forward to do that work, Your Lordships. Voluntary non-fit injuria, Your Lordships, they come forward to do that work, Your Lordships.
When an act prohibits doing a manual scavenger, how can you go on to take protection under this maximum?
Your Lordships, they in order come, if they come, Your Lordships, on that case we could.
Shows that your act is weak. There is a lack in your act.
Despite our prohibition, they are coming forward. Then does it not reflect that your law is weak?
Indeed, no,
inadequate,
Your Lordships.
ambiguous, and unenforceable?
Then you may remove the word rehabilitation from the act.
That is why you have enacted the 2013 Act.
Yes, Your Lordships.
Because the earlier one is not so sufficient.
Yes, Your Lordships.
Then why can't you enact some other strict provision in the Act?
Your Lordships, the strict provisions have been invoked in this, so that only we have provided with the penal provisions where the respondent failed to invoke the domestic remedy and they appeared before this honorable court.
So one small clarification based on the statement which you made.
Highly obliged, Your
Waiver
Lordships.
of fundamental right
Yes,
is
sir.
available in our constitutional provisions, in the Ivana's constitutional provisions.
Your Lordships, no person can waive off his fundamental rights, Your Lordships. So that the government, in order to protect, even though if he come forward and waived off his fundamental right, the government has a duty to protect his fundamental rights, Your Lordships. So that only, in order to protect their fundamental rights and in order to make sure that the persons are not waiving off, losing their dignity of life by employing into such manual scavengers.
Whether your state maintains any data, how many of them from a region are engaged in the same voluntarily, you use voluntary non-fit injury, how many
Yes.
of them are voluntarily involved? Do you have a data?
Your Lords, the Council lacks such data, Your Lordships.
Omission, as our brother judge said.
No,
You
indeed no, Your Lords.
because law enacted 2013.
Yes, Your
The
Lordships.
report was in recently. So why, which prevent you not to collect the data last 10 years?
Your Lordships, the manual scavengers have been enrolled. Like the government had made provisions in the state level as well as.
When your intention is to simply eliminate, why you invade them? Please come and enroll.
Your
Then we will
Lordships-
provide all.
Your Lordships, the enrollment has been made for Yes, Your Lordships, the Council would clarify. In both district level and state levels, it has been made in order to rehabilitate such manual scavengers so that it would prevent them from engaging into manual scavenging, Your Lordships.
Then why need you to give a license to the GHS? Whoever wants to, you can use these people because we have a list with you.
Your Lordships, here we have nowhere given the license to GHS to employ manual scavengers, Your Lordships.
You have only given license to use the devices.
Your Lord,
Machineries and devices to clean these scavengers. This is what.
yes, Your Lordships.
You have not authorized them to employ the men.
Your Lordships, while obtaining permission, Your Lordships, the GHS was saying that NH is another body which would clean the sanitary or the sewage tanks, Your Lordships. But here they have been due to something they have not approached NHS and they have taken this manual scavengers, Your Lordship, so that only we are saying this thing, Your Lordships.
Have a scheme for compensation for the victim. So the as of the person lost their life, the rehabilitation is not only for the person who are doing the job, the family also.
Yes, Your Lordships.
Here, three of them were doing the work, they have lost their life. Think about the children.
Your Lordships, the rehabilitation program is not only for the deceased person, Your Lordships. The dependents of the deceased are also entitled.
Rehabilitation may be given those who are living.
Your Lordships, this particular Safai Karamchari, the judgment which has been passed, the
Council, whether the freedom of profession is a fundamental right.
yes, Your Lordships, it is a fundamental right under 19(1)(g) of Constitution of Yavana.
There will be a restriction imposed under the same Article 19-1G and what a ground that the restriction is imposed.
Your Lordship, in case of public interest, the restrictions can be imposed. Restrictions can be imposed, Your Lordships. Your Lordships, the Council, if there is any other questions or else the Council would like to move on to the issue number 4. Highly obliged, Your Lordships. Your Lordships, whether the biomedical waste disposal regulations are fulfilling the constitutional mandates or not. Your Lordships, this particular biomedical waste regulation has been enacted by Constitution of Yavana under the Environmental Protection Act, Your Lordships. We would like to protect Article 21 of the Constitution, where in the case of MC Mehta versus Union of India, it has been stated that right to live in a decent environment is also a right, Your Lord. It is also a right under Article 21 of the Constitution, Your Lordships.
Which Mehta Council? We have more than 15 Mehtas. With Mehtas you are referring.
Your Lordships,
Footnote number?
Your Lordships, 1987, Your Lordships. In the case of Sri Ram.
What was the doctrine discovered by the Supreme Court in 1987, Mehta?
Your Lordships, absolute liability has been discussed in the case of Sri Ram Food Fertilizer.
Yavana is ready to accept the absolute liability?
Your Lordships, Yavana is nowhere accepting the absolute liability, Your Lordships. If absolute liability is being posted, then it has to be posted to, the onus has to be shifted towards GHS, Your Lordships.
will do with Article 48 capital A of Ivana Consti?
Your Lordships, Article 48A mandates standard of living. Your Lordships, 48A, it is a fundamental, it is a directive principles of the state policy to protect the citizens and standard of living of citizens, Your Lordships. Your Lordship, I would take back my word. Article 48A is a protection and improvement of environment and safeguarding, Your Lordships. Here, this particular act has been enacted with this particular constitutional provisions of 48A, Your Lordships. Because this biomedical waste management has been a inherent danger, Your Lordships. Therefore, we have categorized this particular biomedical waste management into 10 categories, and we have made sufficient disposal procedures, Your Lordships. As the learned petitioner council has been alleging that only incineration is being made as the process of disposal, Your Lordships. Your Lordships, there are many other alternative ways, Your Lordships, which has been used. Best alternative ways from Stockholm Conventions has been adopted, and the alternative methods such as pyrolysis, autoclaving methods, and what is the procedure to carry out autoclaving method, what is the procedure to carry out pyrolysis method has been placed, Your Lordships. Further, Your Lordships, this as they stated.
So which provision of Stockholm Declaration, which declaration you meant? Is it of 72 or is it of?
Stockholm Your Lordships, Stockholm Conference, which is on persistent organic pollutants, an international treaty to protect human and environment from persistent organic pollutions, Your Lordships, which has been mentioned in page 20 of the memorial, Your Lordships. Your Lordships, the petitioner council has alleged that the plastics have been used, which if incinerated would produce dioxins and furans, Your Lordships. But Your Lordships, the very part 2 of this biomedical waste management rule state that this particular plastics are compiling with the standards of BIS standards, Your Lordships. Your Lordships, when incineration has been made, Your Lordships, the data has been the data which has been provided says that 99% has been burnt into ashes, Your Lordships, and further this act provides on what prescribed measurements the effluents has been left to the left out, Your Lordships. Therefore, it complies with all constitutional mandates, Your Lordships. Your Lordships, further, Your Lordships, they said that the act, this particular act doesn't. Yes, Your Lordships. The learned Your Lordships, further, the learned petitioner council said that this act is in a lack, Your Lordships, but there was a time-to-time revisal, Your Lordships. If they don't comply with the biomedical regulations, how is that possible to make time-to-time revisal of this biomedical waste management? The government is well aware that this biomedical waste management causes inherent danger towards the society, Your Lordships, so that only we taking immense measures in order to protect livelihood of the people, under Article 21 to live in a clean environment, we make time-to-time revisals, Your Lordships. Your Lordships.
But your factual says different, council.
Your Lordships.
Because of non-implementation of the same, there are animals who were in the place, then it's simply allowed to spread, which made many human environmental causes. But you said you are too aware and you strictly followed, isn't it? Which one is correct? But
Your
the
Lordships, the statement by the respondents one. Yes, Your Lordships, the fact says that the dogs were of using some anatomical ways of the human hands, Your Lordships. That doesn't mean that comes from this particular biomedical waste management, Your Lordships. There are serious offences which are happening where various other things have been happening. Highly obliged, Your Lordships. Therefore, the Council would like to submit before this Honorable Supreme Court that this particular biomedical waste regulations is very well comes with its constitutional obligations and constitutional mandates, Your Lordships. If the Lordships have any other questions, I would like to move on to my prayer part, Your Lordships.
Yes, Council.
Highly oblige, Your Lordships. Prayer. In the light of the issues raised, arguments advanced, and authorities cited, we pray before this Honorable Court may please to the Prohibition of Employment as Manual Scavenger and Rehabilitation Act 2018 is in consonance with the Constitution of Yavana, Your Lordships. Further, Your Lordships, the government of Yavana has complied with various international commitments and to declare the dependents of the disease when not entitled to pay compensation, and furthermore, this biomedical waste disposal regulations are fulfilling the constitutional mandates and expecting this court to dismiss the writ petitions filed by the petitioners and any other orders as it deems may fit in the interest of equity, justice and good conscience. For the act of kindness, the respondent counsel forever bound. Your Lordships.
You have to mention whatever the points you forgot to mention.
No, not repeat. Need not repeat the points. We have already taken
Whatever
them.
the points you forgot to mention before this court, you can have the liberty to.
Now, team yes, sir.
It is pleasure arguing before the bench. Thank you.
Only 3 minutes.
So, now the petitioner team. Petitioner team. Now that, sir, respondent, now that you have wound up your arguments now, we will give you an opportunity for rebuttal. 3 minutes time we will give you. If you want to emphasize any more points, you are at liberty. டயஸுக்கு போனது டைம் இல்லையா, அவங்க டயஸுக்கு அங்கே போன பிறகு டைம் ஸ்டார்ட்ஸ். Five minutes. நிறைய டைம் கொடுத்துருங்க, எக்ஸ்ட்ரா கொடுத்துருங்க. 7 minutes.
Warm greetings to the Honourable Bench. Your Lordship, after the first manual scavenging compensation case in Madras High Court in the Secretary to Government versus Valayaka on dated 7 April 2016, Tamil Nadu seek the clarification to Union of Yavana, and according to an interim Your Lordship, it is under page number 20 and from the top, second paragraph. According to the interim application number 9 of 2016 by the Union of Yavana seeking clarification from the Supreme Court, particularly in respect of the case's responsibility for the payment of compensation should rest with the owner of the premises or the state government. By the order dated 10/5/2016, the Supreme Court made it clear that the state shall be liable to pay compensation to all the victims irrespective of the place of work, Your Lordship. It is also footnote number 90, Your Lordship, and also it has been provided under Change India, Your Lordship. It is also in page number 15, Your Lordship. Change India versus Union of Change India versus Government of Tamil Nadu, writ petition number 2576 of 2017. The same case in the same case, this was stated by Your Lordship in the Honourable High Court, Your Lordship. Your Lordship, the Supreme Court has provided an order, Your Lordship. That is the reason we are stating this here, Your Lordship. The Supreme Court order, Your Lordship, regarding the application of the compensation, Your Lordship. Also, that is the reason why we are stating it in the Honorable Supreme Court. That's the rest. The second, first two issues will be rebutted by my co-counsel. Okay. Okay.
But one thing is, as my brother judge has posted you, how this court can take a bind over the subordinate court decision.
Your
This
Lordship,
is the apex court.
this is not speaking exactly about the decision, Your Lordship. This is regarding the order provided by the Supreme Court, Your Lordship, regarding a clarification interim application made to the Supreme Court, Your Lordship.
Yeah.
After that, during that case, an application was filed to the Supreme Court regarding clarification, Your Lordship.
Very good.
Much obliged, Your Lordship.
Much Your Lordships. Your Lordships, the government has issued standard operating procedure in 2018 by the Ministry of Housing and Urban Development, where how the sewers and septic tanks can be cleaned, which has been attached in the compendium for your perusal, Your Lordships. Your Lordship, so whatever the learned opposite counsel, learned the petitioner counsel has been contending about the first issue, and the third issue will be not maintainable, Your Lordships, and further in the second issue and the fourth issue, where the petitioner, what the petitioner has been claiming, and the respondent, the government of Yavana is has committed to all the international obligations and bounded to the international commitments, Your Lordships. Your Lordships, only if the government is bounded by law, Your Lordships. We have a rule of law. We cannot exceed the rule of law, Your Lordships. Only if the Supreme Court has given may give any directions, the respondent duty bound to obey, Your Lordships. Your Lordships, if the government will come forward, Your Lordship, then the very object of the act of prohibiting the manual scavengers will not be bent, Your Lordships. Much obliged, Your Lordships.